Welcome back to r/LegalAdvice, where people ask questions, get advice, and we get satisfaction. If you are new to my channel, please don't forget to subscribe to join our amazing community, and without any further ado, let's dive right into the stories. And the first one is titled Leased House Delivery Day of Rent Needing Work Done, Strong Smell of Mold and Mildew, Dangling Light Fixtures, etc. with pictures. Where do I stand in terms of the lease? So my day has been downright horrible. I am active duty military that stupidly signed a lease for a house, sight unseen, and I think this is going to cost me. Movers get there same time my wife does, and next thing I know, she is calling me, bawling her eyes out. The house is in pretty poor order, and that is coming from someone who has rented in college towns. Now I am not there with her because I am stuck 1,200 miles away for the next 10 days, so I am feeling like a pretty poor husband. We end up having the movers put everything back in the truck and move it into storage. Over the phone, the landlord sounded reasonable and agreed to return my deposit and pre-rent paid. Later he messaged me saying I needed to stick to the contract. I sent him pictures of everything we found. He keeps saying, "Oh, I'm having a painter come back out this day. I'm having the plumber come out that day." The same is true for the AC unit guy and the cleaning people who he's just having come out today. Don't you think you should clean a house before someone moves in? In our eyes, this should have been done before we got there, and we just want to wash our hands of the whole event. Can anyone on here give me an insight as where we would stand in breaking this lease? And a user in the comments noted, as it stands now, you don't have the grounds to break your lease. Your landlord is not provided to give you a clean dwelling, but he's required to give you a safe one. If the lease is active, for example today is either on or past its start date, I would suggest you give your local building code enforcement office, often a county level inspector, a call to see how fast they can come out and inspect the dwelling. The electrical and mildew/mold issues are by far the most serious, but you need to get someone official to inspect and document the issues before you try to break the lease. You also need to give the landlord a reasonable amount of time, at least a few days, to correct the issues as well. And honestly guys, even though I feel really bad for the OP, he was definitely stupid in signing a lease for a house he has not even seen. What would you do if you were in this situation? Let us know in the comments. Update: landlord delivered the house in disrepair. He's offering to let us out of the lease but not return deposit. Should I pursue code violations further or cut my losses? Yesterday I wrote about what a miserable experience my family had when they arrived with the moving company to the house we signed to lease. Basically, the house was in terrible condition and my wife was just in tears. After going a little bit back and forth, we had the moving company pack everything back up and place it in storage. Talk about a tough decision and position to be in. I emailed and mailed via certified mail a letter outlining various building code violations found on the premises, and it seems to have changed his tone a bit. He is now asking for a letter of cancellation and the keys. He did not say how this cancellation would look financially. We put down a pretty hefty deposit, $6,850, first plus last plus security deposit plus pet deposit, and I am looking for guidance on whether I should continue to push the coding violations and attempt to recoup some of our expenses or just cut our losses and get on with our lives. And a user in the comments suggested you should report him to the county for the horrible condition of the house. Don't threaten to do so if he does not return your deposit, just do it. If the county finds the house uninhabitable or condemns the house, then your lease is rendered invalid and you can seek the entire return of your deposit and damages for housing your belongings elsewhere. You should also send a demands letter for the returns of the entire deposit as well as the costs for storage and a hotel since the house is uninhabitable, and if he refuses, then take him to court. I would be hard pressed that a judge would find the house habitable. So guys, would you essentially fight the landlord or just get on with your lives? Let us know in the comments, and while you're at it, please don't forget to post some star emojis in the comments and also like the video if you want to support me. Thank you very much in advance, all your help is very much appreciated. Update number 3 to the landlord situation. The landlord fixed the majority of complaints, but there were still some obvious repairs needed. Lost faith in landlord and asked to be let out of lease. He obliged but came up with a random number of $1,000 to return to us after receiving the keys. The total amount given before was $6,850, base rent $2,200 times 2, $250 pet and $2,200 second deposit. I never received a letter stating why he was not returning at least our security deposit. Any advice on where I stand if I took this to small claims? And a user in the comments asked, what does your lease say about early termination? Even so, if you broke the lease because of code violations and a violation of the warranty of habitability, you should be getting back at least the first and last month's rent, if not the whole shebang, minus a potential prorated amount for 18 days of rent if you moved in. Update number 4 to the landlord's story. Successfully sued landlord for deposit and won. I filed a small claim against the landlord, hired a process server to deliver the claim. Roughly 30 days later we met for mediation, which was unsuccessful. Another 30 days later we met before the small claims judge and successfully argued my case. The judge ruled in my favor for the full amount and gave them 60 days to pay the ruling. I messaged the landlord today, notifying them that today was the due date. He hastily deposited the amount with confirmation sent to me. All in all, I am happy the whole ordeal is over and I can wash my hands of the mess. I just wanted to update my post on here to show others that they can too follow through with the whole process and right where they have been wrong. And by the way guys, I'm curious, have you ever taken someone to small claims court? Let us know about the circumstances in the comments if you wish. And the next one is titled, Car stolen in February, found it on Tuesday and I took it back. Was what I did legal? In Australia. Whatever NSW means, I'm not sure. I had my car, an 80s classic, stolen in February this year at the same time as a home break-in, and long story short, police were not much help. I travel for work and drive between 3 local cities regularly, and on Tuesday I spotted my car in a place I know I would have noticed if it was there before. Last time I had been past this place was 2 weeks ago. I called off work, had my sister get my spare keys and that evening stole the car back. It is still wearing the same plates it had on it when it was stolen, though I had cancelled the registration by reporting the plates and car stolen to the RTA, our DMV. I told my boss on Wednesday why I had to keep the work car overnight and he was okay with it, but told me I could be in a whole lot of trouble if I have stolen my car from someone who bought it from the thieves in good faith, as it would now be by default legally theirs and I would have to go to the trouble of proving that I had not sold it to them. At the very least, he tells me I cannot admit to breaking into it at all because it was not on property I had legal right to. This is true, I went into the driveway of the house it was parked at and took it from there. At the moment the car is secure in my backyard and is mostly as it was when it was taken from me, with the major exceptions of a missing stereo, and the front seats have been replaced with rubbish boy racer ones. There are some minor things of no real value in it that don't belong to me apart from the seats. Some clothing, an old iPod, some CDs and postal mail, a few months old, to an address that was not the one I took the car from. I have checked the engine/chassis numbers and it still has all the parts it should and no extras. I admit I did not think this through when I took it back. I had it in the back of my mind the idea that I would just tell the police I had found the car on the side of the road by luck and drove it home again and reawaken its registration and insurance this next week. What is my best sensible next step? And a user in the comments suggested, do not drive the car until you have notified the police you found it. You don't want them stopping you thinking you are the thief. I had a car stolen years ago. The police made a point of telling me that if I found it, do not drive it home, but to call them immediately and wait for them. Never drive a car that is on the police stolen list. And I'm curious guys, has anyone ever stolen a car from you? I gotta say, I would be hard pressed to name a single thing that has been stolen from me, except the one time I forgot my favorite scarf in my university classroom. And one of the other students even pointed it out that I forgot it, and they said they gave it to the reception or whatever you call the place where lost items are stored. However, they said nobody ever gave it to them, so unfortunately I never got my favorite scarf back. And the next one is an update to the Australia car stolen story. An uneventful update. I went directly to the police after posting here and admitted exactly what I had done. I had 2 officers come out to inspect the car and they took the papers that I had found in the car. I got a strong dressing down that this was not the way to handle things and that the information about where it was found and what was found in it was less useful to them than if they had inspected it clean. They reiterated that I got my car back, and okay, not through good judgment, but luck. One did say taking it back was technically no more illegal than if I had parked it accidentally on someone else's lawn. I asked about getting the fittings in the car, the rubbish seats, back to the people who were in possession of it, and they said they are not going to want them back. As of today, the car is back on the road, but avenues for catching who stole it and broke into my house are more closed than they would be if I had done things the right way. Lesson learned. Who would have thought that you essentially get punished for stealing back your stolen car? Not me at least, but let's continue to the next one. And the next one is titled, Can the HOA President Ban Hurricane Shutters? In Florida, of course. The HOA president just told everyone that they are not allowed to put up shutters in the event of a hurricane, and anyone caught putting up shutters will have a lien put against their house. Is that legal? Everyone's homes would be destroyed. And a user in the comments said, the HOA covenant is what governs, not the HOA president's word. That said, he can probably make life difficult for you if he wanted to. As in, you might have to hire a lawyer to fight any violation fees they try to assess. If you don't fight it and don't pay it, they can foreclose even if you were originally in the right. Also, state law would override anything the HOA agreement says, but I don't know what Florida law might say about this. And you know guys, this story actually reminds me that there's a subreddit called Florida Man, which essentially only has news articles from Florida. But I gotta say, that is one of my favorite subreddits because the headlines themselves are just so outrageous. However, unfortunately, it is kind of difficult to read that subreddit because I would have to read a lot of newspaper articles, even though they are very interesting, but it would come with copyright issues. Update to the HOA president's story. Since she did not want to believe that hurricanes cause damage, I called the local fire department and they sent over some guys to talk to her. What they said to her, I don't know, but she has completely changed her mind. Now she wants a rule that for any storm higher than a tropical storm, shutters must be put up. And a user in the comments noted, she can go through whatever the rule-making process is to make that a rule. If you joined an HOA where the president can just unilaterally make up new rules on her own, then I'm not sure what to tell you. And the last one is titled, New Jersey, town trying to make me drive through school property. Hi all, I have a real estate question. My driveway currently empties onto a two-way road. At the end of the two-way road is a school which is owned by the regional school district, independent of the town. The town wants to turn the two-way road into a one-way road to reduce traffic and allow parents 2 lanes to line up to pick up their children. By them turning it into a one-way road, this will now force me to drive through the school's parking lot to get back to a public road. The town would get an easement from the regional school district to allow me to do this. However, this brings up a slew of issues for me, such as snow plowing and maintenance, paving potholes. Can the town force me to drive through the school's private property to get access to a public road? Should I lawyer up to try and prevent it? Thank you in advance for your advice. Unfortunately, there was no good advice given, I gotta admit. Update to the town trying to make me drive through school property. Update: after lawyering up and fighting with the town for the past 6 months, the town has decided to vacate the road and both myself and the school district will each get half the road. Now all I have to do is figure out how to keep those crazy parents off my side of the road. And the last one is not really legal advice, but it has to do with HOAs. It is titled, Strategy for Dealing with Dues Owned to an Aggressive HOA. Hello, I am a new member of the forum and I do have an issue with my HOA that I would like to discuss. In this situation, I'm a homeowner and I currently owe several years of HOA dues to the association. For various reasons and mostly economic, I have fallen behind on the payments. The dues are about $250 per year. I owe them around $2,500 or so with interest, and I have owned my home here for about 10 years. Recently, the property management company for the HOA has started to engage in what I can only describe as harassment for alleged covenant violations on appearance of the property, landscaping, etc. This culminated into 2 written final notices being sent to me in the past 2 months. However, there were no initial notices for the same complaints sent prior to the final notices. Also, the complaints are not complete. In other words, I will get a complaint for one issue and then correct it, and then another final warning will come for another alleged issue. These notices are also filled with threats of lien and foreclosure regarding the past due balance, and I think that is the reason behind the harassment. I tried calling the property manager and he was strangely combative with me. We got nowhere on the phone and he only appeared to want to threaten me and basically sent the message that my property will always be in violation until I pay them off. My thoughts on this, along with much research, is that the HOA dues are thankfully low enough that placing liens and trying to engage in foreclosure has not been economically feasible for the HOA to do in most cases. According to court records, the HOA has only taken one homeowner to court, and that homeowner wound up winning against the HOA and is still in the home. Due to privacy, I do not know the details of the case. Also, it seems that the HOA would sort of routinely send out notices of intent to lien for people behind on dues. However, in recent years that has been replaced by use of an outside collections company. The collection company has sent me letters and they also put a negative mark on my credit. So I paid them nothing. I don't want to fight with the HOA, nor do I want to egg them on, and with these letters and phone calls I feel I am probably engaging in that, even if not on purpose. What I am considering to do is to send a simple written request to the board asking for all alleged covenant violations to be emailed to me, along with a reasonable time frame to correct the violations. I need to make sure I receive all the violations at once so I can avoid this "oh, and by the way" type of harassment they appear to be engaging in now. I am also considering trying to organize a payment plan with the HOA, however, I cannot afford to make any large lump sum payments. I am also very interested in knowing the current power the HOA may have or not have with regard to my home, liens and foreclosure. If I do wind up in a serious legal action, I may be able to pay the fees off in total, but I would rather not do that until that final moment. As I have faced much economic trouble in recent years with the mortgage and banks, I know it is best to save the emergency cash for real emergencies. Thanks for any ideas on the best strategy I could use to start to resolve this problem with my HOA. And the first person in the comments said, "Sounds like you are really behind and they are really pissed at you. The violations seem to be just to get even with you or to get your attention. So, dealing with and negotiating about the violations I think would be wasted time and energy since it does not address the root issue, your overdue payments. Try to negotiate a good faith, honest, best you can afford that you will stick to payment plan with them. I think if you folks can come to an agreement and you keep your end of the bargain, the violations will go away. That is my 2 cents. And another person said, "I agree with Bob. I am shocked that they would let you get 10 years behind to begin with. We are not allowed to let a resident go past 12 days in late rent each month without a formal payment plan, for example." Definitely arrange a payment plan. I am not an attorney, etc., but non-payment is non-payment and I don't see any argument to not pay this. It is their job to collect. And another person said, "The HOA certainly has the right to foreclose and there's no financial reason for them not to do so. Any attorney fees, probably $2,000, would be added to your balance." And another person said, "In my market, many of the HOAs have property management companies that also collect dues. When you don't pay dues, it goes to their collection attorney. The HOA collection attorneys here are very aggressive. They go right to filing assessment liens, even for accounts only 60 days past due. It is an effective technique, as assessment liens are public record and get the owner's attention. If the HOA remains unpaid, they do foreclose on the assessment liens, even on over-encumbered properties where they will get the property back. Again, aggressive and immediate collection practices get attention and let all the homeowners know that there are consequences for not paying dues. If you are $2,500 behind on dues, and that is only $250 per year, that is not economic hardship. That is a choice you are making. Call them and make a payment plan as soon as possible. And guys, after doing a little bit more research on this story, I found out that essentially OP is really in the wrong here, because he did not pay any dues at all, and in this case it is not really the "oh bad evil HOA", but instead it was the OP who is simply not paying. Either way, apparently in the end, he came to an agreement with the HOA, meaning that his violations went away and he followed a payment plan made by the HOA for him. And unfortunately, Ripe Stars, with that we have reached the end of the video. I hope you enjoyed today's legal advice stories, and if you did, please don't forget to click the bell icon even if you are subscribed already, just to make sure that you don't miss any of my uploads. In addition, if you haven't already, I would also suggest to check out my Patreon at patreon.com/ripeyoutube. Starting at just $3 a month, you will get access to weekly exclusive Reddit videos. We are over 70 people there already, so it is getting quite cozy. Either way, thank you very much for watching. I hope you have a fantastic day, and I see you again tomorrow.